So we are now going to move on to Module 6 on the subject of leases. Now, there's quite a lot of content in this module, a lot of which, quite frankly, isn't technically difficult. You're clearly going to need to know it for the purposes of your multiple choice test. However, there are elements of this in particular that I am going to be directing you to read on your own. Again, what I really want to do is focus on some of the more difficult aspects, some of the things that I think are quite examinable, and how they might come up. So what we are going to look at by way of overview is, in brief, the distinction between a lease and a head lease. We are going to have a look at the common types of lease. Crucially, of course, the formalities for the creation of a lease, the distinction between a lease and a license, that's very important. We're going to look at the contents of a lease and the remedies for breach of covenant in brief, and we are going to look at the continuing liability for in relation to the obligations under the terms of leases, and in particular the Landlord and Tenant Covenants Act 1995, and in brief we will look at the assignment of leases and the termination of leases. So moving on to your workbook then, in the introduction I remind you that typically the landlord is called the lessor, and he will grant from his freehold estate a term of years absolute, a lease in favour of the tenant or the lessee, and the term of years is usually referred to as a lease or a tenancy. And of course what that relationship is creating is a number of rights and obligations as between the landlord and the tenant, but typically, of course, and most fundamentally, the right for the tenant to exclude the landlord from the premises. Now, just by way of terminology and to make sure we're quite clear about what it is we are talking about, the landlord will typically create a lease out of the freehold estate, which he or she holds, and what they then have to sell on is called the freehold reversion. So the landlord, if he or she is selling the freehold subject to an existing lease, that will be the freehold reversion. And the person who acquires that freehold reversion is called the assignee of the reversion. If a lease is granted out of a freehold, that clearly is just a lease that exists, but provided that lease doesn't prohibit it in some way, there are sort of multitude of relationships that can exist below that. But if a tenant then grants a further shorter lease of those premises, what he or she has created is called a sublease, and at that point his lease above him is then called a head lease. And I've given you a little example in the workbook with the rather inspiringly named Peter and John. But what I've also done in your workbook is just give you a little pictorial representation of that, so that you're quite clear that in my example, A owns the freehold of Blackacre, which is an estate, as we know, that's registrable in its own right at the Land Registry. And out of that freehold estate, if he grants a 20-year lease of Blackacre, that lease is also registrable in its own right because it exceeds 7 years, as we have seen from an earlier module. So the first thing to observe is that we, of course, then have 2 title numbers in relation to one piece of land. And moving further down, if A grants a lease to tenant 1 and then tenant 1 grants a shorter lease of the premises or part of the premises to tenant 2, that original lease is called the head lease, and the subsequent lease, subsequent, is called the sublease. And of course, it's possible to create further leases below that. I've just reminded you that if a lease is created that's of more than 7 years in duration, it's registrable in its own right. And the workbook reminds you of the types of property that are commonly the subject of a lease: residential, commercial, and of course agricultural. What I will leave you to have a look at for yourselves is the part of the workbook entitled Common Types of Lease. That takes you through the idea of a fixed term tenancy, maybe allowing for early termination, but we have seen from our definitions of the leasehold estate that the fundamental distinguishing feature is that at the time the lease is created, we know when that interest is going to come to an end. We've got a slightly quirky one in the workbook called a reversionary lease, which is a lease which essentially is entered into but doesn't take effect immediately, and the tenant doesn't go into possession immediately. Not necessarily something that one comes across that often in practice, but nonetheless exists. And you've got the different types of periodic tenancies mentioned in the textbook, in the workbook, as well as contractual periodic tenancies, tenancies at will. So I'll leave you to have a look at those. But one thing I do want you to pick up on, because again, I think it's quite examinable, as I've mentioned, at the time a lease is created, we know when it's going to come to an end. But the workbook reminds us that an arrangement isn't capable of being a lease, and it will be void for uncertainty if at the time the lease is created, we don't know when it's going to end. Might not end for a very, very long time, but we still know that a 999-year lease, for example, does have an end point. And we try not to burden you with too many cases on this course, because quite often they're not that relevant. But nonetheless, Lease and Chandler, and it is a T in there, it's not Chandler, it's Lease and Chandler, clues in the date really, 1944. That was a key case, which, as the workbook reminds us, was basically the case that established that a lease which, when it was created, you didn't know when it was going to end, would be void for uncertainty. And as the workbook reminds you, typically during the Second World War, many landlords granted tenancies which were expressed to last until the war ended. And of course, at the point it was created, we didn't know when the war was going to end. So please, I've mentioned that an exam tip, do look out for that, because I do think that's potentially quite examinable. So, for example, as I've put in the workbook, if a lease is going to end when someone becomes king, or there's some other scenario that we don't know when it's going to end, then that arrangement would be void for uncertainty.